Good morning or afternoon, depending on where you may be. Thank you for holding, and welcome to today's Cloud Services Community Webcast. Our topic for today is 5 legal issues raised by a cloud practice. All phones are currently in listen-only mode, and later there will be a question and answer session with instructions being given at that time. You may also ask a question at any time using the chat window located in the control panel. Chat questions will be answered at the end of the presentation with the rest of the Q&A portion. Today's session is being recorded, and you will be provided a copy of today's materials following the call. Now I'd like to introduce today's expert speaker for the webinar. Mark Del Bianco is the principal of the Law Office of Mark C. Del Bianco, located in the Washington, D.C. area. His practice focuses on the U.S. and international clients that are using new technologies to provide innovative communications, products, and services, including fiber networks, competitive broadband service providers, satellite resellers, data centers, and telecom agents. Most recently, his client projects have focused on the legal issues arising from the move to the cloud, particularly issues around data privacy, data security, SLAs, and new cloud business models. Prior to opening his own practice in 2003, Mr. Del Bianco spent 11 years in the Washington, D.C. office of Skadden Arps, and his legal experiences also include 3 years in the Antitrust Division of the U.S. Justice Department. He is a Phi Beta Kappa graduate of the University of Maryland and the Yale Law School. All right, Mark, go ahead and take it away.
All right, thank you, Sam. It's a pleasure to be here today, and I'm glad I can help educate the channel about what to expect as it moves to the cloud. I'll be sharing what I've learned representing both cloud services providers and channel partners who are expanding into cloud services. So the key thing that it's an assumption I'm making, but it's something that everyone needs to understand, and that is that the move to the cloud is here, and it's disrupting everything in telecom and IT, from hardware to software, from small businesses to the biggest companies in the United States. It's been talked about for years. I know every time I went to channel partners or talked with some of my clients, they would be pushing the idea of the cloud, the cloud, the cloud. Well, I think we're at the point where it's finally happening. If any of you were at the Channel Partners show in Vegas in March, you saw what I'm talking about, I think. The change in the makeup of exhibitors on the show floor at Channel was a shock, at least to me. Most of the providers of the old telecom services, things like long distance, T1s, voice conferencing, they were gone. And they were replaced by a lot of new providers of cloud services. Software as a service, infrastructure as a service, or platform as a service. And right now, what I'm seeing is that the channel partners on the telecom side and their counterpart VARs on the IT side are really being impacted by the move to the cloud, and they're not alone. I've got a few data points about companies that are a whole lot bigger that are being impacted by the same move to the cloud. IBM has had shrinking revenues in both 2012 and 2013, mostly from declining hardware and consulting sales. And there's been a lot of chatter, I guess you'd call it, that when they lost the CIA cloud contract to Amazon in 2003, it really showed that they were not a leader in the cloud, and it was possibly not a good indicator of a good future for them. Hewlett-Packard, another big company in the hardware space, has had 11 straight quarters of declining revenues, and they've announced that huge layoffs are coming. Cisco has been hit in different ways as a hardware provider also, but their CEO seems to be in some ways focusing on the move to the cloud, and in other ways recognizing its potential for complete disruption. Last month, that it would thoroughly upset networking and computing markets as soon as 2018. And he says, now obviously he's pushing his own products, but he said it would he thinks it will render as many as 2/3 of the world's corporations today non-existent entities. I think that may overstate the case. But he did say that also that no networking equipment manufacturer, other than Cisco, of course, will survive what he called the brutal consolidation, and that out of the top 5 computer hardware and software players, only 2 or 3 would be meaningful in as quick as 5 years. So if the large players are seeing the movement to the cloud as that disruptive to their businesses, you can imagine the potential for what it might do to the businesses of partners and VARs selling in the channel. So what's the state of the indirect sales channel today for cloud services? One of my clients recently described it as the wild, wild west. And the reason, I guess, is it's a developing industry. And there are a lot of new cloud providers that they have developed a small base of customers. They've got products, but in general they're unfamiliar with indirect sales and unsure about how to create a channel partner team. A lot of them also, I've found, don't understand the drivers of channel sales professionals, and so they find it very difficult to set up their systems and to incentivize indirect sales partners. What we found is that there's a really wide variation in cloud provider compensation, depending on a variety of factors: the type of product, the nature of the service provider, and so on. Similarly, the terms and conditions in the cloud contracts and the agency agreements and the rules of engagement for the indirect sales channel can vary wildly. I'll talk about this a little later, but I would say that one of the things that I've been seeing over the last year that has changed or has created some uncertainty is the growing entry of firms that started out in the commercial real estate space and then moved into co-location and are now moving to supplement their co-location offerings with bundles of cloud services run out of their data centers or run out of the or in tandem with the data center. And what I'm seeing with those is that they are bringing a different mindset of commercial real estate issues, problems, and practices that is very different from what traditionally has been, to the extent there can be a 15-year-old tradition, I guess, in the telecom and IT indirect sales spaces. And so I'll talk a little bit about that later, but that's something that I think a lot of people need to be aware of. There's also no standardization of SLAs and this is not just the indirect sales channel, but it's in general with cloud services. So that makes it difficult to do apples-to-apples comparison for both buyers and for the sales channel itself. Another difference that is causing issues, and I'm not sure that this is going to change at any time soon, is that the cloud services model often is a scalable and quickly scalable offering that is provided on a month-to-month basis, or even scalable on a daily or a weekly basis, and there may be no long-term contracts involved, or if they are, they're sort of for a base minimum with usage-based scalability, which makes it difficult to incentivize partners to sell it, I think, sometimes. And finally, something that it's a prediction, but I don't really think that there's much doubt it's going to come true, and that is that there's going to be serious consolidation of the cloud service industry over the next few years. It's just inevitable, just as we saw consolidation in telecom and various other industries as they became both bigger and more mature. So what are the risks that channel partners and looking at it the other way, I guess, that the service providers run in this kind of Wild West market today. Well, the first is that you're going to choose the wrong services to sell and that you're going to choose the wrong providers to sell. And that, of course, is an issue at all times, but it's more of an issue in a market that is just developing and is very fluid, which is what the cloud services market is today. Another risk, and it's one that I don't think a lot of people think about, but it is that potential customers will not understand what they're buying, and they'll have unrealistic expectations. And then when they do make a purchase, their expectations may not be met. And those expectations can relate to cost, they can relate to accessibility, they can relate to uptime, or to other qualities of the service. But in many ways, there's a lot of fluidity in these services, and people's expectations have not solidified and often are not clear until after there's been a purchase. Another risk is that the service provider that you're working with as a channel partner will not pay some or all of the commissions that you've earned. A fourth risk is service provider bankruptcy. Anybody that lived through the telecom crash of 2000-2002 knows that this is a real potential, in fact almost a certainty, as an industry matures and consolidates. So it's something that has to be kept in mind by anybody in the industry over the next few years. And the final risk for a channel partner that I've seen over the last few years is a service provider that you're using or that you're working for will be bought out, and the buyer will either stop paying commissions or will have less of a commitment to the channel and will be less than helpful, and perhaps cut your commissions or take other steps to minimize their costs. So what can you do about those risks? Well, some of them just have to be accepted. I mean, there's no foolproof way to make sure an agent contract survives the service provider's bankruptcy. If your service provider, one or more of them, are going to go bankrupt, you're probably going to be out of luck. Anybody that lived through the telecom downturn, again, the 2000 to 2002 or so, you've probably seen this, you've been through it. You can, as a partner, mitigate some of these risks, though, through smart business practices. The first thing that you can do is to select the right portfolio of services to sell. And that's going to be hard to do. It's going to be harder in the cloud services world than it was in the telecom world or than it was in the IT world for VARs. The reason is there's going to be a lot more offerings. They're more complex. They require more knowledge to both sell and to understand and select. So what you need to do is you're going to be spending, I think, a lot more time educating yourself on the technology, talking to customers about what services they really need and really want and are willing to pay for. And then once you have some sense of that, you have to figure out which of the various service offerings are going to fit what you can sell, what you can learn, and what your potential customers want. The goal here, obviously, is to try and find the equivalent of what the T1 was, say, in the late 90s. Something to keep in mind is it's not clear there's going to be anything that is the equivalent of the T1 in the sense that it's something that a lot of businesses and potential retail customers want to have or have to have. There's a lot more choice on services than there was on telecom bandwidth or technology 15 years ago, and it may be that there isn't going to be a single or even a handful of services that are sellable in the same way. A related thing that a partner can do to mitigate some of the risks associated with the uncertainty in the cloud services world is to educate your customers once you've become educated, and then don't overpromise. And don't let the service provider overpromise either, to the extent you're involved in the sale process between the two, between the customer and the service provider. Because from what I have seen, both in the development of the telecom space, since 1996 Act was passed, and in the comparable recent developments in the cloud services space, is that there is a real tendency on sales guys, and I know this will shock everybody on this call, but there's a real tendency to overpromise and to say that a service will do something that it may or may not be able to do. And to the extent that you have that occurring, you are more likely to run into problems down the road. On a similar vein, the last item here is that you need to facilitate the communication between the customer and the service provider, so that if the customer becomes dissatisfied, you are not the target of their wrath. Whether that's a lawsuit or whether it's bad-mouthing you in the community and among potential customers, you want to be able to separate yourself and remain on the good side of your customers. So what we've come to then is the meat here, which I think is the 5 key areas that I have found where good legal drafting can mitigate some of the risks. I won't say that it eliminates the risks, and I won't say that it mitigates all the risks, but there are 5 areas where you can, if you have some negotiating leverage, and of course that's always a key question, where you can take steps to have language that protects you down the road. The first is ensuring accurate commission payment. The second is ensuring commission on all purchases by referred customers. The third is ensuring or trying to ensure that you've got continuity of commission payments if a particular service provider is acquired or merges. The fourth is reducing the incentive for your service provider, whether it's the original service provider or one of an acquirer of that provider, to stop or to decrease your commissions. And then the fifth is obtaining some sort of liability or indemnification for service provider errors and service failures. And in many ways, these 5 issues kind of track the risks on that I mentioned in the preceding slide. So the first, and honestly, a lot of these issues will be familiar to people that have been in the business for a while, because if you go back to my list of risks right here, excuse me, all those risks that I identified here are all risks that were shared by or were part of the telecom industry between, say, 96 and 2002 or 3, where you had the huge growth of the industry and then the consolidation, the bankruptcies, and the maturation. So if all these risks look familiar, they are. It's because they were the same risks that existed as telecom became deregulated 15 or 18 years ago. All right, so let's start with the first issue, which is how do you make sure you receive proper credit for existing business and confirm your commission accuracy on an ongoing basis? The first thing you got to do is to make sure that as part of your agreement, you're getting a monthly report with specific data about revenues being received from your referred customers and what commissions are due to you. This is actually quite a bit more important now than it was in the past, for at least for telecom, because most services in telecom have not been usage-based in recent years. So your MRC, your monthly recurring commission, or your monthly recurring revenue on which commission was calculated, has generally not varied too much from month to month, unless you're increasing your sales and identifying new customers. So this model now, the cloud services model, to the extent that it's scalable and much more usage-based, is more similar and presents the same risks as what in many ways might be considered lower tier telecom services, such as long distance, which has been sort of the key usage-based service I think that a lot of partners sold in recent years. So you need to get the monthly report, and you need to have the right to audit the service provider's records to confirm the accuracy of your commission payments. But you've got to be proactive in doing it. I can't tell you on how many clients I've seen, how many partners who had practices where usage-based commissions were a substantial part and didn't bother to look at anything other than the bottom line each month on how much commission they were getting. They were never double checking to make sure that the same customers were showing month to month. They were never double checking to ensure that they were being paid on the various types of commission. You've got to not only have provisions providing you with the monthly reports and the right to audit, but you've got to be proactive in reviewing those reports and doing the auditing if you decide that an audit is necessary. Sometimes and often it's not necessary because you're comfortable that the commission report is substantially accurate. But just having that provision in there with the right to audit can be tremendously important. The second key issue where you can have provisions in your agreement that really strengthens your position and reduces the risk is making sure that mechanisms are in place for renewals and upgrades. And I would say, I mentioned earlier that the influx of companies from other vertical industries, particularly commercial real estate, has sort of brought a new set of expectations and contract provisions to some of the service providers. And this is one area where I have found a lot of pushback from the new entrants, I guess. And that is they've brought in a lot of practices from the commercial area. For example, in telecom at least, it's not been generally a requirement that there be some sort of written authorization, the equivalent of a letter of authority or an agent letter from the potential customer before the agent can register the opportunity with a carrier or a service provider. Now, recently, I've seen more contracts probably in the last 6 months where that's been at least an initial requirement than I had seen in probably 5 years before that. And it's not all companies coming from the commercial real estate space. It is more a growth of an expectation that the agent or channel partner is bringing an opportunity and may not be entitled to all future business that the customer brings to the service provider. So that's why most service providers, at least initially going into the negotiation, are no longer offering automatic evergreen clauses. They may be offering fairly long clauses, buyout clauses, but an automatic evergreen, which was fairly common is not as common as it was just a couple of years ago. In most cases, what they are allowing or providing is that even in a situation where they're paying on upgrades and renewals, they require a lot of involvement on the part of the agent. One of the dangers there is they require the involvement, but they don't offer a corresponding duty on their part to notify the agent if they become aware of an upsell opportunity to an existing client. So one of the things that I strongly would recommend is, if you're going to be required to be involved in order to obtain credit or get commission on renewals or upgrades or upsells, that you make sure that there's a corresponding provision that says, okay, if you don't ask me to be involved, I don't have to do anything. And if you don't ask me to be involved at all, or you don't even notify me of an opportunity, then I do get credit. So it's basically forming more of a partnership where each of you talks to the other. The third key issue where you can, I think, reduce your risk is in terms of consolidation. As I said, future consolidation is a definite certainty. It is going to happen. You don't know who or what's going to survive, except if I were guessing, I'd say Amazon and a few others are definitely going to survive. Google would be one of those, at least within the next 10 or 15 years in terms of cloud services providers. But many of the smaller providers, and probably even some of the what we consider large cloud services providers today, are not going to be survivors. So when they are acquired or merged, you want to make sure that you are continuing to be paid. The big danger here is not the acquisition of one company by another through a stock purchase, because in that situation, or a stock exchange, in that situation all the contracts go with it. The real danger is if there is basically an asset purchase. I won't bore you with the legal differences, but basically the asset purchase allows the acquirer to just take those assets that it wants to and not to take the associated liabilities. There are some legal constraints on this, but a lot of times there is no opportunity for an agent to make sure that its contracts go with the assets that are being acquired. Those of you that are in the area probably are aware of the TDMI Birch case from last year, where TDMI was actually had a clause in its agreement that said, if I'm paraphrasing here obviously, the clause basically said that if the assets that were associated with the agent agreement were bought, which essentially meant that the customers were bought and the services that they were provided, that part of the business was bought, then the agent contract would be deemed assigned along with those assets. And a jury actually found that as a result of that, the agent's right, the part of the contract that gave the agent the right to continue to receive commissions, was automatically assigned to the buyer, which in that case was Birch, and that Birch owed back commissions to TDMI. I have not checked recently. There was a two-part trial on that. There was the initial part, which found liability on the part of Birch, and then there was going to be a second part that would determine the amount of the liability, which, as I recall, could have been up to $20 million, I think. but as far as I know, there's not been an actual decision, although on what the amount owed is. It may be actually that in that case there was a settlement, and nobody will ever know publicly, but the concept is one that can be used by other agents to protect themselves, or at least try to protect themselves as the consolidation of the service provider, of the cloud service provider industry occurs. The fourth area where a lot of risk can be reduced is in the shifting of the incentive for commission shortchanging by service providers. And the way that this is done is basically just to include an attorney's fee shifting provision in the contract. As those of you that have had the unfortunate experience of being involved in litigation may know, the U.S. Judicial system provides that unless there's a statutory provision otherwise, or unless there's a contract provision otherwise, each party in a litigation bears its own costs. And what that rule does is it makes it more well, it places a burden on smaller companies for whom the initial cost of litigation may be relatively high compared to their income, and also it forces them to calculate not only the possibility of prevailing, but also how much of their potential winnings are going to be spent on attorney's fees. What a fee-shifting provision does is it provides that the loser pays the attorney fees in any litigation. And it completely changed, in my experience with smaller and medium-sized partners, it completely changes the calculation. And the reason, let me give you an example. Providers will roll the dice sometimes on whether the agent will take legal action. And they'll either nickel and dime and reduce the commission, or they may stop paying the commission entirely if there's, you know, just a year or two on a contract, on a customer contract. And they'll figure, I mean, I don't know what the number is that they use, but from looking at it, it appears to be somewhere in the $50,000 to $100,000 range for a lot of these service providers, where they would stop paying or they would reduce the commission. So essentially the partner may be out $50,000 or $100,000 by the time the contract is over, and they will take the chance that the partner will simply not sue them, because when they make the calculation, that $50,000 or $100,000, or even more sometimes, will be eaten up by attorney's fees. So even if they win, they end up with little or nothing more than they already have, and they have a lot of psychic energy and time spent on the corporate side dealing with the litigation. So what I often will try to do for clients in that position is to get in a loser pays winner's attorney's fee clause in order to convince, in order to make it less likely, much less likely, I might add, that the service provider will stop paying for no reason at all. One thing I've found on that's interesting is that often it is the business side, and sometimes just the CEO, that will change the dynamic in terms of paying providers, paying partners, excuse me. So I've had a couple of instances where where we've gotten involved in the initial stages of litigation, and it's become very clear, because we had both the merits on our side and the loser pays attorney's fees, that soon after it became clear to the general counsel on the other side that we intended to actually follow through with the litigation, the general counsel went to the CEO or the management team, and the case was very quickly settled on terms that were completely favorable to the partner. So that shows that even having the clause in there can be very beneficial, even if you don't have to go through fully with the litigation and collect on the clause, because it becomes on the side of the service provider a calculation of, okay, I'm going to lose X, plus I'm going to have to pay not only my attorney's fees but their attorney's fees, so it's just not worth it. The final issue that I'm going to talk about, where you can again take some legal steps, but it's, of the five, I think the most difficult, is to seek indemnification for both service provider errors and service failures, but also for just getting for any costs you incur if you get dragged into a lawsuit between a customer and a service provider to whom you've referred the customer. As I said, these are very difficult clauses to negotiate for, and your ability to negotiate these types of clauses is going to depend on leverage. And I've mentioned leverage a couple of times. It ought to be obvious, but one of the things that I'd point out is that you really want to be negotiating these types of agreements when you have some business to bring to the table. You don't want to be going out and negotiating 4 or 5 of these sort of on spec. You want to be able to say, look, I'd love to do business with you. I have this customer that has this much need. The day after we sign this agreement, I will introduce you to the decision makers, and we can go ahead and start trying to sell to them immediately, and you're going to have a lot of new business. The more of that you have on the table when you're negotiating, obviously the better the terms you're going to get out of the service provider. So for indemnification, if you don't have some strong opportunities to bring to the table at the time you're negotiating, it's going to be very difficult. But it's definitely worth trying for, and it may be that you want to hold off on negotiating an agreement with a service provider or more than one service provider, depending on how much you potentially have, in order to aggregate a couple of different clients and be able to go to the service provider and say, I really need the clause of an indemnification clause. I want to sell with you. I want to be your partner, but one single lawsuit could put a lot of small and medium-sized channel partners in the hole, whether it puts them out of business or simply takes up all their time and all their free cash flow to the point where they just can't grow the business for a year or two while the litigation is pending. So it's a difficult reach or ask, but if you can get an indemnification clause, it's definitely worth it. I have a few final thoughts that I'd like to share. First, there's a theme that's run through this, and that's that the move to the cloud increases the complexity, both business and technical, for any channel partner. You're going to have to learn new technology. You're going to have to become more of a trusted advisor for your referral clients. And you can't sit back in the way that perhaps many channel partners were able to 5 or 10 or 12 years ago. You can't sort of get a book of business going and then necessarily expect it's going to continue, if not on an evergreen basis, at least for 5 or 10 years. As you're learning the new technology and you're becoming a trusted advisor, you need to be aware of the balance between breadth excuse me, and depth. And what I mean by this is that you can learn about selling cloud services, but you have to choose whether you're going to learn a lot about a few services or a little about a lot of services, whether you're going to choose between breadth and depth, because you only have so much time, money, and effort to put into this. And particularly small and medium channel partners, you're not going to be able to become experts on all the varieties of cloud services. that are available out there. A piece of advice that I give to all my clients, whether they're selling in the cloud services business or something else, is that you need to be aware of the eggs in one basket problem. You shouldn't rely on one carrier or service provider, or even one or two, even a couple. You should try to spread around to the extent that you can, so that the failure of any of these risks that I've identified that occur as to a specific service provider, if they occur, then you have other backup service providers, and you can at least continue part of your business. If there's a bankruptcy or if there's an acquisition where your contracts are not assigned along with the customers, you don't want to be in a position where a failure of one service provider or two service providers puts you back to the starting position. There's also a similar eggs in one basket problem with particular services, and this relates to the depth and breadth issue that I just mentioned. You've got so much time and so much energy, and you don't want to just learn one or two types of services and become fluent in them and able to sell them, because if you've chosen wrong and those are not services that the potential customers you're contacting want, you run into a real problem. And you also run into a problem of just your own time and energy. So that breadth, depth, and eggs in one basket problem is exacerbated by the fluidity here of the services and of the channel. So the final thing I'd say is that unfortunately there are no easy legal fixes to the risks involved in selling cloud services. But if you take as many of the steps as I've identified as you can, you will, at least with regard to each service provider, have minimized some of the risk. And by having multiple service providers, you will minimize overall the risk that if any of these risks occur, you end up with a business that's very small and having to start all over again selling. I think that's about it, Sam, and you're going to go ahead and ask for questions, right?
Yep. Thank you very much, Mark. That was fantastic. Mark is right. We will now open up for questions. If you would like to ask a question, you can do it one of several ways. You can raise your hand using the raise hand button located in the GoToWebinar control panel. Or you can also, if you prefer, ask a question via the chat box or the question box that's in the lower right-hand corner of your screen. If at any time your question gets answered, please lower your hand or let me know that your question has been answered in the chat box. So we will. And there's a few questions that came in immediately. We will be sending out a link to the PowerPoint deck along with a link to the recording. So that will not be an issue. Everyone will get a copy of those materials in the next day or so. All right, Mark, here's a question. How can users avoid vendor lock-in and exit if needed?
That is, when people are doing webinars, the first reaction, and I always dislike it, is to say, that's a great question, Sam. But it's your natural reaction when you're sitting here to do that. The answer to that is not, again, a simple one, and it sort of depends whether you're reselling for yourself. In other words, whether you're moving from being a partner, a referral partner, to offering a resold bundle or of services, or just a resold particular service. I think the way that you can avoid vendor lock-in is in the customer contracts. You have to make sure that the customer has access to data at all times, including in the event of bankruptcy, because there have been situations where some companies went bankrupt or were shut down for some reason, and the customers lost access to their data and were locked in. So in the contracts themselves, this question actually, it seems to me, would be something that a channel partner would need to know how to answer, but would not necessarily be involved in the negotiation themselves, because it would be between the customer and the service provider. But people are going to want to know, well, you know, if you've recommended this service provider, how do I ensure, or how do you know that I'm not locked in? And again, you have to look at the contract and make sure that you have access to the data at all times, including potentially in a bankruptcy situation, and that they're not keeping the data in any kind of proprietary format that you would not be able to read and use if you did get the data back. So that, I think that's the way you handle that.
Great. All right, we have another question that just came in. As a relatively new IT service provider, when negotiating with a larger vendor, how do you approach negotiations? When most commonly in these types of companies, you're dealing with a partner manager whose job is to sign you up and to get you to do a 30-day trial and not discuss legalese.
It comes back, in my experience, to leverage and to having potential business that you can dangle in front of the service provider and say, I want to discuss the legalese. You really don't want to be in a position where you do sort of what you just described, Sam, where you go in, sign something, do a trial, and they say, oh yeah, we'll see how the trial goes, and then we'll amend it or change it however you know to fit what we need. That rarely happens. If you don't get what you want at the beginning, it's very rare that you can get it later, unless again you come back with a huge sale and you say, this, you know, I'm happy to give this to you if I get A, B, and C, but if not, then I'm taking it to your competitor. And that does happen all the time. I have clients that go back to renegotiate agreements that they either weren't really paying attention to. One of the dangers that I've seen is that a small sale will appear on somebody's radar screen, and they will pick a service provider, sign an agreement based on the expectation that that'll be either the only or one of a few small sales to that service or with that service provider, and then something happens and all of a sudden there's an opportunity for a lot more business with that service provider, and they're constrained by the fact that they didn't negotiate a good agreement at the beginning. So I guess what you have to do, and I recognize that in a lot of cases people don't want to do that or they don't think it's worth it, but getting the agreement right at the beginning is a whole lot easier than trying to renegotiate it down the road.
Excellent. Another one, what do you need to know about cloud SLAs?
Well, as I've said, they're in flux right now. There are some very good ones and there are some terrible ones. Depends both on the provider and on the service. And a channel partner needs to know sort of just enough to be dangerous at this point, I think is the way I'd put it. You have to understand for most types of major services what the SLAs are, just so you can answer questions about the general outlines of the SLAs with your customers. So again, it comes back to the customer coming to you, you saying try provider A or B, and when they ask why or how good is the SLA, you have to be able to talk about it. So this is one of those areas where you do need to educate yourself. You may need to spend some time with the channel manager or the people in the channel of the service provider and get them to give you a cheat sheet on the SLAs, or explain why their SLAs are either industry standard or much better than industry standard. I'm sure they'd all say. It's just a matter of educating yourself, I think. You're not going to, again, this is one of those areas where unless you're reselling services or bundles of services, you're not going to be involved in the negotiation of the SLAs. You're just learning enough to converse and explain coherently why a particular SLA is good or bad, or why it's industry standard.
Okay, great. Well, we'll give it a few more seconds here if any other questions filter through, but as of right now, it looks like we are run through it. So, yeah, well, okay. Well, Mark, thank you very much. You covered the material very well. So well, in fact, that we've run out of questions. So, thank you, ladies and gentlemen. Again, Mark, thank you for your expertise. We appreciate you very much.
Thank you.
All right, that concludes our conference for today. Please do take a few moments to fill out your post-event survey. We love everyone's input, and we use it for future webinars and conferences that we put together. So please fill that out post-event, and we appreciate it very much. So everyone have a great day, and you may now disconnect.